lawyer, and for more than 40 years, she has been working at several NGOs, working on human and women's rights organization, as well as an environmental issue. She was awarded as a leading women's rights advocate in Indonesia from Nestle, the Asia Foundation, Femina Magazine, Metro TV, Matra Magazine, as well as Kartini Abad-ini and Women in Development Award. In 2007 and 2008, Globe Asia magazine put Miss Katia Sungkana as number 51 of 19 powerful women in Indonesia. Thank you, Miss Katia Sungkana, to come to join us today. So your second speaker, Mr. Amit Sabi, is the counsel to the Aban Tribunal. He will speak on the setup, why it was needed, and what were the challenges that Aban Tribunal faced during the process. Mr. Sabi is a London-based lawyer with an international practice in human rights, arbitration, and litigation. He acted as counsel and rapporteur to the Iran Tribunal, a people tribunal which investigated mass killing of political prisoners by the Islamic Republic of Iran in 1980s. He also served as counsel on the China Tribunal, Uyghur Tribunal, and Aban Tribunal. Thank you, Mr. Sabi, to join us. Finally, your third speaker today will be Professor Carla Firstman. She is a judicial panelist of the Aban Tribunal and will discuss the finding of the People Tribunal and then the recommendation. Professor Firstman joined the School of Law at Essex in January 2018. She is a barrister and solicitor. She was Fernand Browder Senior Fellow at the European University Institute of Florence. She was visiting professional at the Center for International Governance and Justice at Regnet, Australian National University, and Janine Randolph Senior Fellow at the United States Institute of Peace in Washington, D.C. She worked for the United Nations High Commissioner for Human Rights in Rwanda, where she focused on the detention crisis in the country and early domestic criminal trials, which were instituted by the Rwandan government in the aftermath of the 1994 genocide. Professor Firstman worked with the International Secretariat of Amnesty International in London on a special initiative on trials in the Great Lake region of Central Africa. Then she moved to Sarajevo, where she was appointed as executive legal advisor of the Commission for Real Property Claim of Refugee and Displaced Person in Bosnia and Herzegovina. In 2001, she joined Redress, first as legal director, and from 2014 to 2018 as a director. During her tenure, Redress won the MacArthur Foundation Award for Creative and Effective Institution. In 2022, Professor Firstman won the Essex Faculty of Art and Humanities Supervisor of the Year Award. We are glad you could be here today to share your insight on Aban Tribunal's the people response to impunity. Now, let's get straight into the context. Please, Ms. Katia Sungkana, the floor is yours.
Yeah, wait a minute. Okay. Yeah. Thank you, Mr. Petrelli, for this opportunity. It's my honor to be one of the speakers of this public lecture and sharing my experience in involving in the People's Tribunal. First of all, I also would like to thank the Gino Global University, especially through Regina, who invited me to this event. I don't know whether Regina also joined this public lecture. Yeah, I just would like to share my experience in involving in People's Tribunal and explain the importance of the People's Tribunal to fight against impunity. Yeah, actually my first experience is in 1997 when the economic crisis happened in Indonesia, and the government, supported by World Bank, provided aid for the poor people. Yeah, yeah. At the time, I'm working as human rights lawyer, and also the director of legal aid for women. Yeah, so we collected data from the community that the head of the village did not provide the aid or distributed the aid properly. There's only people who close to him who get money or rice for the poor, or a job for the men. And then we invite other activists, especially from Urban Poor Consortium, to discuss how to do advocacy. And we came to the conclusion that we must establish a community, People's Tribunal at the community level. And the judges selected from the community, and we managed to make the head of the village attended that People's Tribunal, and the judges also managed to give a judgment to the head of the village that he did something very wrong, and corruption and so on. And the community managed to throw out, to expel the head of the village. That's my first experience that made me like very optimistic, and people also can use our legal or our law to establish our own court. And the second experience is when I was invited to the Women's Tribunal on Comfort Women in 2000. In 2000. That's at the time the government, a group of lawyers in Japan launched invitation to the victimized countries like Philippines, China, Japan themselves, Malaysia, Indonesia. I think there are 7 victimized countries of the Japanese occupation, and there are 200 victims, and namely comfort women in those countries. Yeah, and of course, I accepted this invitation to be a prosecutor of the Women's Tribunal, because that's, I think, that's really will be my first experience internationally. Actually, even yeah, my English is so limited and so on, but we managed to collect data with the help of the researcher, both from Indonesia and Japan, as a basis of our what is it? A document, yeah, a document for the prosecution. That's I think it took me like 1 year to prepare that document, because in Indonesia it's everywhere, not only in Java but in Sumatra and even in Buru Island, and also together with the team from Timor-Leste at the time. And this process enriched my experience in dealing with past human rights violation, and I learned a lot from all the people who involved in that women's tribunal. Yeah, I learned that the establishment of People's Tribunal is actually nothing new, because it started in 1967 as the initiative of British philosopher Bertrand Russell and Jean-Paul Sartre, also a philosopher, from a French philosopher, Simone de Beauvoir, also philosopher, and a women's rights advocate, of course, together with their colleague, to try the United States of America, the perpetrator of war crimes in Vietnam. That's and since then, around 100 People's Tribunal have been held, and similar trial was also held in the Vienna Human Rights Conference, when women's group also established a women's tribunal, yeah, to advocate that women's rights are human rights, in which the Vienna Declaration was adopted. Yeah, although as a citizen initiative, People's Tribunal is not legally binding. That's maybe that's it, the limitation of People's Tribunal, and it has also no legal or real power to enforce its judgment. Yeah, but it carries the moral authority, demanding the right acceptance and enforcement by the international community and national government, and also it also function as the historical record, and also human rights record, where the government do nothing about the human rights violation that occurred. It also demand enforcement of the rule of law by the international community, and for victim, survivor, and their family, a people's tribunal is a very important healing process, so that they are able to raise their voice and gain the confidence that they are victim and not criminal as a label or as accused by their own government and a responsible perpetrator. That's also a function of people's tribunal. Yeah, and although people's tribunal is not a formal judicial institution, its judgment and legal consideration may be recognized in international and national fora, and also influence the lawmaking process both nationally and also internationally. Yeah, and it also can be used as the basis of argument for filing a legal case at the national level, as well as creating justice and human rights culture for preventing the reoccurrence of the same human rights violation. That, yeah, like my experience in organizing International People's Tribunal on human rights violation in Indonesia, 65 and 67, that mass killing and genocide even. Also after the establishment of International People's Tribunal in 2015, the government in 2016 organized a national symposium to collect data and also like a hearing to the victim. That's never happened before. Yeah, the government coordinated by the coordinating minister of human rights and law invited most of the representative of the victim. Yeah, that's never happened before. Even after that, when we organized a seminar to demand the rewriting our historical textbook. That's yeah, military and TAC and fundamentalist mass organization attack my office, because the seminar is organized in my office, Indonesian Legal Aid Foundation. And since then, this, most of the victims in various cities have been attacked by the TAC when they gather or have a meeting or whatever. Yeah, that's the lesson learned from my own experience. And a good lesson learned actually came from the Guatemalan Women's Tribunal, where the judgment has been used by 15 ecocide victims to file a case, and they won. Yeah, they won, and the cost ordered to provide provide compensation, and also tried two perpetrators of crimes against humanity. That's also the lesson learned from the People's Tribunal. Even I told you before that there is the limitation of the judgment because cannot be enforced. I think it is the first time in history that a local court in Guatemala has sentenced a perpetrator by taking into account the background of the local criminal law as well as international law, as also structured in the judgment. Yeah, and also learning from Women's Tribunal in 2002, a group of gender experts in the UN also managed to advocacy long before the judgment on gender issue in ICC. I think that's also a good lesson. So People's Tribunal can also function to record the atrocities and provide full documentation of the case. That's like the Aban Tribunal. We have record with this very good analysis of the fact that managed we collected by the victim themselves or the lawyer, or and also international community. The judgment can also be used as a lobbying document at the national and international fora, using all kinds of legal procedure provided by national and international laws and convention. So my experience in this matter, for example, when we got a judgment on Women's Tribunal in 2002, we did advocacy to the CEDAW committee in New York. At that time, the government of Japan report was reviewed by the committee, and at the time it's a good time for us to lobby the member of CEDAW committee using that judgment, and also provide data, and also pose question, because the NGO also allowed to have a special forum with the member of CEDAW committee. So the People's Tribunal also functioned to fill the gap in the international legal system, as well as it may act as a precursor to an official court or tribunal by creating publicity and political pressure as part of a broad campaign to force a state-based mechanism to deal with the issue. Yeah, even where an official mechanism exists, People's Tribunal may nevertheless be convened because they offer something qualitatively different or beyond what an official tribunal is capable of providing. That's the, so it is a moral responsibility for every member of the global society and a common task for human rights advocates to contribute to end the cycle of impunity and to restore justice and dignity of every human being everywhere. That's the, I think, the message of the People's Tribunal, that the legal system, national or international, not only for formal legal institution or formal court, but also can be used by People's Tribunal. That's, I think I must stop here. So if there is a question, I'm happy to answer. That's,
Okay.
Thank you very much.
Thank you very much, Mr. Katayusungana, for your informative and comprehensive presentation. Now we are going to listen your second presentation. Mr. Savi, please go ahead.
Thank you very much. And thank you, General University, for organizing this event. As the moderator mentioned, my name is Hamid Sadi, and I've acted as counsel for Aban Tribunal as well as 3 other people's tribunals. I give you a short background as to the events that led to the establishment of this tribunal. Basically, Islamic Republic of Iran is a theocratic dictatorship. It's one of the kind in the recent history that it's ruled by iron fist, enforcing not only the laws of Islam, but the laws that is considered by the ruling class as Islamic. It doesn't matter whether it has a source in Islam or not, but they apply it whenever it fits them. The 42 years rule of this government until 2019 was full of people objecting, demonstrating against the regime, and it has been a continual demonstration against the regime from the day that it was established. Actually, the first demonstration was on 8 March 1979, less than a month after the establishment of the Islamic Republic, by Iranian women coming to the streets objecting to the enforced hijab and other problems. So this has never stopped in Iran, and the government had never had the approval of the people for the policies it implemented. The present problem happened in November 2019. November in the Iranian calendar is called Aban, and therefore the tribunal is called Aban because of the atrocities that were committed in that month. And the government decided to increase the price of petrol 3-fold without making any announcement and notice in advance, because they knew this would receive a massive objection. They made preparation for disturbances that may happen and put all the security forces on alert. The government has different types of means of suppression. Primarily, they have the Revolutionary Guards, which is a devout, so-called devout Islamic fanatics, and they are prepared to carry out any atrocity at the as the government tells them, in order to fight the opposition groups. Another group is Basij. Basij is a militia mostly of zealot youngsters. Normally they're recruited at the age of 16, 17, 18, that sort of thing. It has some similarity to Hitler's SR that was established in late 30s in Germany. And it acts more or less like SR in its way. Then you have police forces, which is sometimes brutal, but not as brutal as the Revolutionary Guard and Basij. On the top of that, they have plainclothes officers that mingle in the people. They agitate people to take actions and do things that would create possibility for the security forces to suppress them. The security forces in Iran are well trained to fight demonstrations. They are not, this is Revolutionary Guards that failed in wars and all these things, but they have been very successful in killing their own people, brutalizing them, torturing them, and they have done that for many years with a lot of experience. However, the announcement created an unexpected reaction in all the major cities and towns around the country, in 29 provinces out of 30. People came to the streets the day after the morning after the announcement was made and blocked the roads. They stopped the cars getting to petrol stations, and slowly demonstrations started in all the cities across the country. Although the regime was prepared for some sort of disturbance, they did not expect that sort of reaction and such a widespread opposition to the system. The people that were making these demonstrations were mostly the ones who were either neutral or supporter of the government. So they felt that the government owes them something for years of putting up with all the difficulties that the regime had created for them. So they came to the streets, and slowly their slogans became political. By the afternoon of the first day, the government felt that this is a much larger event that they had expected. So they called the National Security Council, and on an emergency basis. The National Security Council, which is headed by the Minister of Interior, but in fact was attended by the President, and somehow the leader was also involved, decided to take all the necessary steps to stop the demonstrations. And they instructed the security forces to exercise all means, including lethal force, to stop the peaceful demonstration of unarmed people. They also cut the internet off to make sure that demonstrators cannot communicate with each other or report the incidents abroad that would create a lot of negative publicity for the government. In the 3 days that followed, the security forces attacked the peaceful demonstrators using military-grade weapons, shotguns, and other lethal weapons. Many demonstrators and passers-by, mostly youngsters, including children, were killed or injured because of the pellets being fired in the large crowd. A lot of people had pellets in their body. They could not go to the clinics and take them out because they would be arrested. Some lost their eye because the shotguns were aimed at the torso of the demonstrators. There are not very clear and established reports, but the estimation is that around 1,500 people were killed in this 3-4 days, and thousands of people were injured, probably around 7,000 or 8,000. A lot of people did not report their injury because they fear being arrested and tortured. So they lived with the pellets. Some of them had their pellets in their body a year later when they were reporting or 2 years later when they appeared before the tribunal. The brutal suppression of the peaceful demonstration created a major outcry, not only in Iran, and the families of victims appeared on many international media condemning the unnecessary and disproportionate use of force by the government. 3 human rights organizations called for international organization to review the atrocities committed by Islamic Republic. And finally, they decided that the better way to deal with this, and in an urgent way, is to establish a people's tribunal. So these 3 organizations invited the judges, 2 of them who are here, and myself to act as prosecuting counsel. The establishment of the tribunal was announced on the anniversary of the November atrocities in 2020. The benefit of the present-day international media is that we managed to make this announcement heard in Iran over and over the 24 hours following the announcement. In the announcement, we asked for evidence from whoever inside or outside Iran to give evidence and testimony for the forthcoming tribunal. We provided a WhatsApp number, and following our announcement, for 48 hours, this telephone did not stop ringing. Message after message came, and by the end of 48 hours, some 240 messages were recorded from people, most 90% from inside Iran, offering to give evidence, to provide documents, and all the requirements that the tribunal needed. This was a very unusual event in the sense that you normally get witnesses from those who are outside the country if the regime is still in power. To get evidence from inside the regime, with a brutal regime like Islamic Republic, creates a lot of problems, especially for the counsel team. The main and most important problem is the safety of the witnesses. The witnesses who give evidence from inside Iran are certainly exposed to many risks. The regime will get at them, and probably if you make any announcement in advance as to who the witnesses are, they will go and get them before they can give the evidence. And the first advice we received is that we should not use any recording on the computers of the names and details of the witnesses. So only one person in the counsel team was given a book and a pen to write down the details of every witness there, and don't share it with anyone else, and don't put it on a computer. Handwriting was is still the safest way of keeping secrets. Each witness was given a number. For each witness, they spent at least 18 to 20 hours on average to talk to the witness with WhatsApp and get the evidence of the witness, transcribe it, make sure that there is no personal detail in the witness statement, then translate that to English. And the team produced something around 130 witness statements. Of course, we couldn't use all of them. And we presented each witness with a number. Even during the hearing, we called them witness numbers, so and not any name or detail of the witnesses to be issued. Also, another problem was how do you get evidence in a live testimony from inside Iran and present that to the tribunal. The other aspect of it was that the tribunal was fortunate enough to enter into agreement with international media, and they managed to cover the 5 days hearing live, and all of them was broadcast to Iran. So something around 15 million people inside Iran were watching, while people gave evidence from inside Iran against the regime. The witnesses include also some security officers. So here is the government and states in power, but in cities and towns around the country, people are giving evidence to an international tribunal sitting in London, and their picture is broadcast live to the people back to Iran. Just imagine if during Hitler's time, there could have been evidence given from the camps or from those suffering from Hitler's atrocities, and that would have been broadcast live to Germany, so people in Germany could have seen. Probably the history would have changed because people knew what's happening in those camps. The same thing happened in Iran. We made sure that the witnesses cover their face, put dark glasses so even the eye cannot be checked. And for those who were more prominent, and probably they had a voice recording of them, we provided voiceover. So one of the council team would listen to the evidence in Persian, repeat that in Persian, and then it gets translated for the tribunal. So the whole structure was devised on the basis of keeping the identity of the witnesses protected. Some witnesses decided to give evidence in their own name without covering their face. These are mostly the parents or close relatives of those who had been killed. One of them, when I called him to say, why are you giving evidence in his own name, says, I have nothing left. They killed my son. And what is left for a father like me in my old age? They can do whatever they want to me. He gave evidence in his own name, and he's in jail. He knew that this will happen, but he's now being accused of propaganda against the regime and have a sentence against him. We established it, we started the tribunal hearing, the 5-day hearing in November 2021 on the second anniversary of the event. So it was still very close to the time that the atrocity was committed, and it received a massive reaction inside Iran. And this created a major problem for the government. The Islamic Republic of Iran was furious about this tribunal. They made every effort to stop. The deputy foreign minister, on the second day of our hearing, visited Foreign Secretary in London and threatened him that if this tribunal is not stopped, we will not negotiate anymore on the nuclear deal with you. A further hearing was also organized in February to hear more witnesses because we ran out of time in the first one. And ultimately, the judgment was issued in September 2022, which I call it, Carla, who was a judge of the tribunal, would explain further to you. In total, we had 52 witnesses. The council also named 160 people who were involved in these atrocities with the detailed background video clips of their statements and the events that happened within the geographical area of their jurisdiction. Of course, 11 of them being leaders of the country, the leader, the president, the relevant ministers, so at the national level, and in each province, whoever was responsible. And for each one of them, there is a file, so eventually they can be prosecuted on the basis of this information. So that concludes my presentation of how this tribunal worked. If you have any question at the end of this presentation, I will be glad to answer them. Thank you.
Thank you, Mr. Sabi, for your great presentation. And let's move to the third speaker, Professor Fersman. Please take the audience.
Thank you so much. And it's really a great pleasure to be here. And for me, to be involved in the Aban Tribunal was really an eye-opening and important experience. I have been involved in a variety of different justice processes over the years, and this People's Tribunal was the first People's Tribunal I had been involved with. I, as well as all of the other judges, felt extremely moved by the evidence, and it was an experience that I will live with forever. It was a very important experience. To start, I want to explain or give some of the reflections on the perspective of the judges and some of the decisions or choices or issues we faced when considering how to approach the proceedings. But firstly, just to say something general about the People's Tribunal, there's something really powerful about People's Tribunals, particularly for countries where there is absolute impunity. What a People's Tribunal does, it says, we don't accept that the only legitimate space for justice is justice delivered by the state. So yes, it's a policy that's absolutely necessary when the state simply refuses to conduct credible investigations and shields those responsible from justice. But it's also a policy of empowerment. People coming together to say, we deserve justice. And if the state won't provide it for us, we'll do it ourselves. There's no naivete about this strategy, which, as Mr. Sabi has already indicated, put a lot of victims and witnesses at risk, and which in the short term will be quite difficult to implement, at least inside Iran. But justice starts with having a factual record of what happened and assigning responsibility. Accountability and punishment is a longer-term goal, but we can already see that this will be possible to a certain extent. The first People's Tribunal on Iran, the Aban Tribunal, which Mr. Sabi was involved with, which issued its judgment in 2013, it exposed evidence which ultimately saw an Iranian official, Hamid Nouri, prosecuted under universal jurisdiction legislation in Sweden. So he was found guilty of being a key figure in the 1988 executions of Iranian political prisoners, something that the Iran Tribunal, the People's Tribunal, was very key in exposing and providing evidence about. But also the Aban Tribunal judgment, which was released in September 2022, in the midst and as everything was developing with respect to the wide protests, with respect to the killing of Masha Amini. The judgments, the final judgments, the full judgment came out in November 2022. It documented, of course, the methodology of how the Iran regime responded violently to protests. And this violent crackdown was being replicated on the streets of Iran in real time. So there was this sense of urgency, and the Aban Tribunal was one of the impetuses for the Human Rights Council decision to establish a fact-finding commission on the current protests. So all is connected somehow. And we see that these processes are all connected in different ways. But of course, there were challenges. Inevitably, without the state participating, the tribunal had an obligation to find a route to be as robust as possible in the examination of the evidence. The last thing that anyone would need would be a process which simply rubber stamped an outcome without being rigorous. It was important to be rigorous for the sake of the victims, but also for the sake of truth and for justice. At the same time, it was crucial to treat the victims with dignity and with respect, to recognize also that any gaps in the evidence where they existed, though there were not very many gaps, that these gaps weren't the fault of the witnesses, but they stemmed from the very context of the impunity, the lack of official state investigation, the lack of state transparency was naturally going to produce certain gaps. So for the judges, there was a need to be creative about how to analyze the evidence without always having the same kind of evidence that you would necessarily have when considering a domestic prosecution. People's tribunals have a variety of different formats. We, as the judges, the panel members, were very conscious of the need to be as formal as we could, as rigorous as we could, because we wanted to give that ceremonial sense of justice as well. So in the way in which the People's Tribunal operated, we wore gowns, we had a ceremony, we were sure to cross-examine, or from the judge's perspective, some of the witnesses. We asked very tough questions. We always were very careful to have a rigorous approach to the evidence, and to look for patterns, to look for similar evidence between witnesses. As Mr. Sabi said, the tribunal was highly visible in Iran. It was watched almost, one could say, like a soap opera. This was both good and bad. So it meant, on the positive side, that there were more and more people who wanted to testify or give information as the proceedings were unfolding. People were engaging, and this was really clear, and this gave this sense of empowerment and importance, which was very positive. But at the same time, victims and witnesses, their protection was a challenge. The government was actively trying to intimidate those witnesses it knew about. It was a very tense environment, but we very much had the sense that victims were excited about the prospect of telling their stories, because this was so unique. They never got the opportunity to tell their stories because justice was completely blocked in the domestic context that they found themselves in. With respect to the judgment itself, we also were very conscious of the need for it to have meaning for victims. So we really tried to quote as much as we could from what victims and witnesses told us and from their statements, because we thought this was important. We tried to go in as much detail as possible to arrive at a sense of what was happening in different parts of the country, so victims could see their experiences reflected in the judgment. At the end of the day, the judgment was an acknowledgement of all that they had gone through. It was important that they saw themselves in the judgment. The judgment itself, what were our findings? Here too, there were choices that we had to make. The focus of the prosecution case was ultimately to demonstrate that what happened was a crime against humanity. The judges, in their analysis of the evidence, took a layered approach. We wanted to show that these were not simply events which came out of the sky, but there was a deep connection with how Iran perceives dissent and responds to dissent. So our starting point was freedom of assembly and the rights of protesters. And from here, everything else flowed. We also wanted to focus on state responsibility in addition to individual criminal responsibility. So a good part of our analysis focused on how Iran, using the full apparatus of the state, purposefully set out to breach individuals' fundamental human rights on a massive scale. This was important because the events were not acts of a few rogue officials. They were clearly part of a government orchestrated plan. So the rights and the obligations we focused on, all recognized by Iran through its ratification of the International Covenant on Civil and Political Rights, were the right to peaceful assembly. Here, just to mention, Iran, on the face of it, allows for protests to take place. But when you look behind its legislation, it's very clear that there's virtually no open space for any dissent, for any position to be put forward, which goes against the government's line. We also looked at the standards and the limitations related to the use of both less lethal and lethal force. Here, as the evidence demonstrated, the protesters were shot at randomly. Also, different forms of tear gas, water cannons, pellets were used indiscriminately. So we tried to make the connection between the standards on the use of force and how they were breached in relation to the protests in a very particular way. We looked at the right to life. We looked at arbitrary arrest and detention, enforced disappearances, torture and other prohibited ill treatment, sexual violence and rape, the right to access justice, and the right to dignity, including a dignified burial. With respect to the right to dignity, this was something we tried to emphasize quite a lot in the judgment, because an interesting aspect of which was very consistent across many of the witnesses who testified was that it was a struggle to get the bodies of their loved ones who had been killed returned to them. Often it took a lot of time. Sometimes they were not returned, but when they were returned, the families were under strict instruction to bury them in a very particular way, which often did not comply with the rituals which are in place in the country. So families found this most distressing, that they could not even have an appropriate burial. And part of this had to do with disinformation, the security forces wishing to not have information being widely disclosed about the number and nature of deaths. But that was an issue which was clearly a focus for the tribunal in its judgment. On the issue of crimes against humanity, we found that the crimes of murder, imprisonment, enforced disappearances, torture, sexual assault, and persecution, at least speaking for the majority with respect to persecution, were established by the evidence beyond a reasonable doubt. So this is important, the standard of beyond a reasonable doubt, given that the evidence was brought together by civil society, by witnesses coming forward. There was no formal state investigation, but the evidence was so consistent and so compelling that we were able to find crimes against humanity beyond a reasonable doubt. So that, I think, is a very clear and very strong finding. We found that there was an attack against the civilian population and that this attack was widespread. The Iranian government, using its security forces, pursued a plan to commit serious criminal acts against large-scale protests that amounted to a widespread attack on the civilian protesters. The majority also found beyond a reasonable doubt that the crime against humanity of persecution on political grounds was intended and committed by the state of Iran. And this is really quite important, and I think quite significant from the perspective of international criminal law. While the protesters and bystanders caught up in the protests they're not a usual kind of political group. Despite that, we found that the protesters, as persons who deigned to dissent in a country which does not allow for any dissent, were perceived by the government as a political group. And that in and of itself wrought these acts within a persecutory context. So anyone identified by the security forces as being opposed to the supreme leader's regime formed part of the political group which was targeted by these forces and their fundamental rights severely attacked or curtailed. The panel concluded that crimes against humanity was proven beyond a reasonable doubt, as I said. It was able to do so based on the presentation of very consistent, reliable evidence from numerous witnesses located across the country who had personal knowledge of the events or who were themselves victims of those events, as well as expert and video evidence relevant to the government, their security forces, and the protests themselves. With respect to individual criminal responsibility, we found that there was a strong suspicion that many of the persons listed by the prosecution were individually criminally responsible. Reasonable suspicion is a lower standard of evidence, but our view was that it constituted a good cause for further individualized investigations. The panel also unanimously considered that the evidence established a clear case to answer that 13 individuals were criminally responsible for participating in the plan to commit the crimes against humanity that we had found established beyond a reasonable doubt. A case to answer is based upon the balance of probabilities, namely that those discussed below are more likely to have significantly participated in the criminal plan. So this clearly demands a trial process to determine their guilt or otherwise, according to the criminal standard of proof, and in furtherance of due process and accountability by the Iranian government and or the international community. With respect to the recommendations, we made a series of recommendations to the Iranian government and to the international community. I won't go through all of them, but just to say, beyond the obvious ones, which are for the Iranian government to proceed with an effective investigation into the criminal responsibility of these acts to afford reparation to the victims and the families. We did try as much as we could to focus on the need for specific performance. It's important to recognize that there are a number of individuals who remain detained as a result of their supposed participation in protests. We called for their immediate release on the basis that their detention was arbitrary. In addition, we called for a number of persons were subjected to even to the death penalty for their involvement in protests. So we called for that to be overridden. We called for the reprisals against persons who had participated in any way in the process to be ended. We also encouraged the government to set up a commission to consider how best to resolve the issue of dealing with the dead and to consult with family members. This, I think, is a really important finding, which goes directly to the deep despair that witnesses expressed in their testimony, both their written witness statements and before the tribunal, about the sense of, it's more than frustration, it's a sense of despair that they were not able to properly bury the dead. So this is an ongoing thing. With respect to the international community, we called for sanctions, we called for accountability, and we called for more investigation. So we hope that these matters will be taken forward. We hope that progressively we'll see the kind of accountability that Iranian citizens deserve. In conclusion, all that can be said is that every member of the Aban Tribunal was extremely moved, but also angered by the evidence we heard and by the bravery of the witnesses who testified. This is not simply a novel exercise for them. This is their justice. It's the start of their justice. So we're all very committed to ensuring that the verdict is known and that progressively this stain of impunity can finally be lifted. Thank you.
Thank you so much, Professor Persman, for your insight and your complete analysis of the judgment. It was really helpful, I think. So I hope you all enjoyed this amazing presentation. And now we are come to the question and answer session. So I want to remember to who is connected on Zoom, they can write the question on the chat panel and I will report it to your speaker. For the people that are here in the room, let's see if someone raising their hand. You have a question? Yes, please. One moment.
First of all, thank you for shedding a light on the importance of people's tribunals and the entire working of the Aban Tribunal. And so my question is particularly on the dissenting opinion of Ms. Rohan. So she dissented with the majority judgment on the fact that on the crimes of persecution that it was not beyond reasonable doubt that you can establish crimes of persecution against the perpetrators in this case, in the Iranian government. So does the members of the panel, board members of the panel, as Professor Firstman and Professor Sabani have any comment on the dissenting opinion, as well as a comment from Mr. Dhabi would be appreciated as he was just counsel and direct interaction with the witnesses. Thank you.
Shall I take the question?
Yes,
Sorry.
please take.
I believe the question related to the dissenting opinion of Ms. Rohan with respect to the crime of persecution. So the question was asking for more detail about that. It's very difficult for us to talk about someone else's opinion. So I encourage you to read the judgment, which provides a clear view. But what's important to note is that there was no differing view on the facts. The view was on the law. Does the law related to persecution allow for the scenario that the majority found, which was that the individuals didn't necessarily have to have a common political view, because of course there were many of the people who were targeted were actively protesting, but there were also bystanders who were actively targeted as well. So from the perspective of Ms. Rohan, she didn't see how that could fall within the definition as it has been interpreted in different judgments of the crime of persecution. The majority in opposition to that felt very strongly that this was at the most general level a desire to quash dissent. And what was most important in considering the crime of persecution was how the Iran government perceived those who were dissenting, or those who it perceived within this group involved in the protests. So that is really where the debate is. How wide is the crime of persecution, and particularly the notion of the political side of the crime of persecution.
Thank you, Professor.
Other question? I don't think so. If I can, I will ask a question to you. I have many questions, but I will try to give you one that collect all my doubts. So I think that the recent event in Iran demonstrated that we have a policy on violation of human rights by the Iran government. And recently, the Human Rights Council in November 2002 decided to establish an independent international fact-finding mission to investigate alleged human rights violation in Iran. Now, my question is, do you think that they will receive the cooperation of the Iran government? And if not, they will be able to gather evidence? Second question, they will cooperate with the judgment or the finding of the Aban Tribunal? They will use your terrific job on fighting impunity, or they will do something independent from the People's Tribunals? And last question is about, do you think there could be the elements for the Security Council to act under Chapter 7, and in particular, I refer to the responsibility to protect? This is my question. Who want to answer? It's the same.
I will answer part of it, and the rest I leave for my colleagues. Basically, there is no question about the policy of the government of Iran to disregard human rights. They have done this from very early days of the establishment of the regime. 3 days after the establishment of the regime, they started executing opponents or members of the previous regime without any trial, without any process, without any right to counsel, ignoring all the basics. And the regime continued for the last 44 years to attack its opponents anywhere in the world. I mean, there have been assassinations and killings in many countries, including in capitals in the world, in Berlin, in London, in Paris. They have done this with total disrespect for international law, for the relation with the other countries, and they have been found guilty of murder. We still have some members of the regime in jails in Europe, and this is ongoing on. The main purpose of the Aban Tribunal, as Professor Fressman referred to, was to break this image or wall of impunity that had existed in Iran for so many years. In spite of all the atrocities committed by the regime, and in spite of massive and deep corruption in the system, not a single member of the government had ever been prosecuted for these crimes. They never allow anybody from their own people to be judged on the basis of Iranian laws, existing laws of Islamic Republic. None of them had been brought to trial. So the impact of this judgment, and which can be felt in the present process inside Iran, is that this wall of impunity seems to be crashing down. People are realizing that these people are vulnerable. The ruling class cannot survive with all these atrocities. So that's why people have taken the law into their hand. They're coming out. People have taken the front line battle against the regime. They have stopped wearing the Islamic hijab. They are coming out, and the regime cannot do anything because it's so widespread. They cannot put everybody in jail. So they have pushed the present regime to the corner, and I hope they will succeed. I leave the issue of the Security Council action to my learned colleagues to address that.
Maybe if I can just add slightly, On the fact-finding mission and whether the evidence from the Aban Tribunal will be helpful, the mandate of the fact-finding mission is focused temporarily on the current the current protests, the crackdown on the current protests. But what the Aban Tribunal judgment does is it provides to the fact-finding mission evidence of a playbook. This is how Iran cracks down on protests. That is, of course, relevant in terms of how the potential for similar facts and the ability to analyze and appreciate what is happening now in a much deeper level. So we do hope that it will be instructive, but of course the fact-finding mission has to be absolutely independent and look at all of the issues that it's been mandated to look at with a fresh eye. With respect to the Security Council, we can see from other countries how challenging it can be geopolitically for the Security Council to come together with respect to the issuance of a Chapter 7 mandate. But we know that it's happened. It has happened. Will it happen with respect to Iran? Let's say I'm an optimistic person by nature, so I will keep that optimism. But there's some obvious challenges with respect to the politics.
Thanks so much for your answer. So I think that we have covered all the bases. So we have finally come to the end of this virtual public lecture. On behalf of Jindal Global University, thank you very much, Ms. Nakatayusungana, Mr. Sabi, and Professor Fersman for addressing this interesting topic, and thank you all for joining us today. A special thanks to Ms. Regina Paulos, who made this meeting possible. And please give a warm applause for the speaker and for your all. Thank you.
Thank you very much.
Awesome. Thanks again for your time and participation, and have a great rest of your day.